Hello everybody. Today's topic is the Hindu Marriage Act 1955, and this is part 1. So, the title is This Act may be called the Hindu Marriage Act 1955. It extends to the whole of India except the state of Jammu and Kashmir and applies also to Hindus domiciled in the territories to which this act extends who are outside the said territories. Introduction. The Hindu Marriage Act 1955 was intended to secure the rights of marriage for the bride and groom who are Hindu and are bound under the sacred bond of marriage under any ceremony. The law does not define the kind of ceremony since there are several ways a man and a woman may carry out this religious act. This act was floated after several cases were seen where both man and woman were petrified or humiliated under a fraud case in the name of marriage. This act is binding to any person who is Hindu, Jain, Sikh, Buddhist and is not a Muslim, Christian, Parsi or Jewish and is governed by some other law. This law is binding to any person who is Hindu by birth or Hindu by religion. Now some components to make you aware about Hindu marriage law. Section 2 of Hindu Marriage Act 1955. This section says marriage amongst Hindu in any form irrespective of caste or creed or amongst any person who is bound under Hindu Marriage Act 1955 like Buddhist, Sikh, Jains and so-called Hindus is a Hindu marriage. And the section 3 of Hindu Marriage Act 1955 says this act revoked the prohibited degrees of relationships which was defined in Samritis and have defined certain new prohibited degree of relationships. For example, a person cannot marry his brother's wife. However, this provision shall not apply in case of divorce and widow woman. So section 2, which is talk about application of act, says three things. Number 1 is to any person who is Hindu by religion in any of its forms or developments, including a Vairashava, a Lingayat, or a follower of Brahma, Prathana, or Arya Samaj. Number 2 point is to any person who is a Buddhist, Jain, or Sikh by religion. Number 3 is to any other person domiciled in the territories to which this act extends who is not a Muslim, Christian, Parsi, or Jewish by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as a part of that law in respect of any of the matters dealt with herein if this act had not been passed. So section 4 is overriding effect of act. This section says any text, rule or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which provision is made in this act, and any other law in force immediately before the commencement of this act shall cease to have effect in so far as it is inconsistent with any of the provisions contained in this act. And section 5 of Hindu Marriage Act 1955, as per this section, the Hindu marriage is not a so much of a religion and is more of result of a mutual consent. Provision under section 5 is section 5 of the act marriage can be solemnized between two Hindus. Now the next is section 6 of the Hindu Marriage Act 1955 basically specifies the guardianship for marriage. This guardianship for marriage was repealed in 1978 after the Child Marriage Restraint Amendment was passed. This amendment increased the minimum age requirement for marriage in order to prevent child marriages. And the section 7 ceremony for Hindu marriage. This section says a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. whether such rites and ceremonies include the Saptapadi, that is the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire. The marriage becomes complete and binding when the 7th step is taken. Section 8 of the Hindu Marriage Act says this section basically introduced the provision of registration the marriage under this act, and section 9 of Hindu Marriage Act 1955 defined the restitution of conjugal rights of husband and wife bound under this act. Section 8 of registration of Hindu marriage says for the purpose of facilitating the proof of Hindu marriages, the state government may make rules providing that the parties to any such marriage may have the particulars relating to their marriage entered in such manner and subject to such conditions as may be prescribed in a Hindu marriage register kept for the purpose. Second point is notwithstanding anything contained in subsection 1, the state government may, if it is of opinion that it is necessary or expedient so to do, provide that entering of the particulars referred to in subsection 1st shall be compulsory in the state or in any part, therefore, whether in all cases or in such cases as may be specified, and where any such direction has been issued, any person contravening any rule made in this behalf shall be punishable with fine which may extend to 25 rupees. Third point is all rules made under this section shall be laid before the state legislature as soon as may be after they are made. The Hindu marriage register at all reasonable time be open for inspection and shall be admissible as evidence of the statements therein contained. Any certified extracts therefore shall, on application, be given by the register on payment to him of the prescribed fee. Notwithstanding anything contained in this section, the validity of Hindu Marriage Act shall in no way be affected by the omission to make the entry. And the section 9 says restitution of conjugal rights tell about when either the husband or the wife has, without reasonable excuse, withdrawn from the society of other, the aggrieved party may apply by petition of the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. Section 10 says about judicial separation. So either party to a marriage, whether solemnized before or after the commencement of this act, may present a petition praying for a decree for judicial separation on any of the grounds specified in subsection 1 or section 13, and in the case of a wife also on any of the grounds specified in subsection 2 thereof as grounds on which a petition for divorce might have been presented. Where a decree for judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court may, on the application by petition of either party, and on being satisfied on the truth of the statements made in such petition, resign the decree if it considered it just and reasonable to do so. And section 11, which says about void marriages. Any marriage solemnized after the commencement of this act shall be null and void, and may, on a petition presented by either party thereto against the another party, be so declared by a degree of nullity if it contravenes any one of the conditions specified in clause 1st, 4th, and 5th of the section 5th. So guys, this is part 1 and part 2 will coming soon. Thank you.